Again, welcome. Thank you for attending McGeorge School of Law's webinar on the California Governor's Office and the Governor's Office role in state legislation. Here's our agenda for today. First, I'll introduce myself and our guest speaker. We'll have a very short overview of our MSL degree program in government law and policy. And then the bulk of our time will be spent on a presentation by Professor Chris Micheli on the Governor's Office. We'll have some short information about McGeorge's online graduate degrees, what makes them distinctive, and next steps if you're interested. And then we will turn again to the substance and a short Q&A with Professor Micheli about his presentation. So at that point, if you have questions, you're welcome to post them in the Q&A, and I will go ahead and read them to Professor Micheli. So here it's my great pleasure to introduce Professor Micheli. Chris Micheli teaches a number of courses at McGeorge School of Law, and he will tell you more about those courses a little later on. Professor Micheli has a long career working with the legislature and working in a lobbying capacity, and he is an expert on California government, and he has a lot of excellent books that he has published and a podcast that he runs, and I will let him tell you more about his projects during our discussion today. I am Professor Jennifer Harder. I am also a professor at McGeorge School of Law. My area of focus is in public agency law, water resources law, and environmental law. And I am also faculty director for online learning and deeply engaged as a faculty administrator for our graduate programs as well as our JD programs. So I am happy to answer any questions about those programs as well. All right, so just very briefly, I wanted to tell you a little bit about our Master of Science in Law in Government Law and Policy. This program is designed for recent graduates from undergraduate and professionals who are currently working, but who are looking to increase their knowledge of law and policy that's relevant to government and legislative issues, seeking perhaps career advancement or seeking to develop those skills that will enable them to make a change in the world. This program is not a JD program. You don't become an attorney, but you do develop that deep expertise in the language and the processes and the structure of law so that you can participate in conversations about law and policy. If you're interested in being engaged in around regulations, for example, development of policy, drafting statutes or commenting on them, this is a wonderful degree for you. A number of the folks who join our MSL include consultants and agency employees and managers, legislative staff, and a whole host of people who encounter legislative and regulatory matters. So if you're not sure and you want to talk more about this, how the degree might benefit you, feel free to contact me, Professor Jennifer Harder, and I'll provide you with my email at the end of the webinar. So McGeorge is a particularly wonderful place to have this MSL, in part because we have our wonderful Capital Center for Law and Policy, which has been part of the McGeorge campus. It's our center for distinction for many, many years. We have deep connections to the Capitol, as exemplified in part by Professor Micheli. Our government law program for JDs has been honored as #3 in the nation by National Jurist this year, and this is the program that we build on for the MSL. So the MSL degree can be earned through part-time, fully online, asynchronous courses. We also have some versions of the MSL program that are residential and full-time, but if you want to do it while working or tending to family matters, you can do it fully online and asynchronous, and I'll talk more about what that means down the road. So without further ado, I would like to turn the mic over to Professor Micheli to talk more about the governor's role in the legislative process. Thank you, Professor Micheli.
Oh, thank you, Professor Harder. Happy to be here and thrilled to talk about both the MSL program as well as my passion for the legislative process. And and happy to address questions at the end. What I wanted to do is talk generally about the governor's role and then pivot to what's going on right now with a little historical look, and then what's happening on the governor's desk right now. Governor Gavin Newsom is a week and a half into the 30-day signing period, which ends on October the 10th this year. It varies between the first year that we're currently in versus the second year, which ends a little earlier, which is the even numbered or election years in our 2-year legislative session. As you can imagine, the governor plays a very key role in the legislative process, despite lawmaking being almost exclusively provided to the legislative branch of government, which of course we would expect. California has the same 3-branch government patterned after the federal government, with the president as the head of the executive branch, of course, the 2 houses of Congress, the House and Senate, in charge of the legislative branch, and then we have 3 levels of federal courts for the 3rd article, or the 3rd branch of government. California follows the same 3-part government, just like the other 49 states, although one of them, Nebraska, actually has a 1-house legislature. The other 49, including California, have 2 houses. We call them the Assembly, which is the larger one with 80 members, and the Senate, which has half the number, or 40 members of the state Senate. So while most of the lawmaking is done by the legislative branch of government, the governor certainly plays a key role. Now, most people know and understand that to be through signing or vetoing legislation, just like the President of the United States does for congressional enactments. But the governor actually plays a number of different roles in the legislative process. If you want to flip to the next slide, we'll highlight a few of those. Sorry, I've sort of covered that. So the governor does play a key role in the development of policy, and the governor, through the budget and through sponsoring or advocating for specific pieces of legislation, can also drive or help set the legislative agenda for the upcoming year. On the next slide, let's start looking at some of those roles. So just like the President provides every year a State of the Union, our California Constitution requires the governor to address the legislature both at the beginning of session as well as the end, to provide a report, not a speech. So every January, generally about a week or 2 after the governor introduces his budget, which is also required by the Constitution of the state of California to be delivered no later than January the 10th, the governor is always asked by the legislature to come and address them in the state of the state. And so in that policy address, while the governor certainly speaks to the current state of California, whether it's economics or anything else, we also know that he can discuss some of his budget priorities and other public policy addresses. Last year, in January of 2020, of course, before the pandemic struck and caused the legislature to miss or not have 9 weeks of their session, which is pretty significant, and they reduced their bill package by basically 3/4, the governor dedicated his entire address to homelessness. But in most other annual states of the state speeches by the governor highlights a number of priorities for the session. The governor also has a power that the president does not have at the federal level, which is that the legislature can be called into a special, we generally refer to it as a special session, although in the Constitution and as a matter of formality, it's referred to as an extraordinary session. Those who have been tracking state politics for a while may recall that under the governorship of Arnold Schwarzenegger, one year he called 7 or 8 different special sessions. So the governor can use them for different topics. Sometimes they're related to the budget. Other times they've been done for big policy areas, including workers' compensation, and in the past to deal with specific issues like wildfires, for example, that have faced the state of California. Interestingly, the legislature over the past 18 months has not been in extraordinary session to deal with the pandemic. They have dealt with the pandemic through executive orders issued by the chief executive, i.e. the governor, and otherwise by legislation. The benefits of special session legislation, very briefly, is that they work on an expedited basis. So a lot of the normal rules that are applicable and that dictate when legislation moves through the 8 to 9 month legislative process is substantially abbreviated in a special session, and then the bills enacted in the special session take effect the 91st day following the expiration of that session. The governor, of course, can and does lobby. In other words, whether it's meeting with the legislative leaders, the 4 leaders, the 2 Democrat leaders in the Senate and the Assembly Speaker and the President pro tem of the Senate, or the 2 Republican leaders, formerly known as the Assembly and Senate minority leaders, can certainly be lobbied by the governor, and they can lobby the governor. And then from time to time, the governor has to undertake meetings or lobbying of individual legislators in order to perhaps secure the final sets of votes on a particularly contentious piece of legislation, or perhaps to close a budget deal or whatever else might be taking place. Some of the big bills, for example, last year, the governor was very involved in the legislative effort to eliminate cash bail in the state of California. So too was the Chief Justice of the state of California, Tani Kantil-Sakaui. So sometimes it's individual pieces of legislation, sometimes it's broader public policy issues. Next slide. The governor and certainly his staff, as well as members of the cabinet that he appoints and that are confirmed by the California State Senate, similar to how the U.S. Senate is required to advise and consent on certain presidential appointments, so too does the California State Senate have the power over gubernatorial appointees, certain ones. And those members of the cabinet, the agency secretaries, about a dozen of them, from, for example, environmental protection to resources to transportation to business and housing and consumer services, et cetera, they often bring together stakeholders or special interest groups to help negotiate issues. We saw that this year on some of the housing legislation. We've seen it in the past on everything from tax issues to transportation funding to homelessness funding. The governor also takes positions on pieces of legislation. Of course, we know that occurs on the generally 800 to 1,100 bills that hit the governor's desk each year of a legislative session. But the governor's office often takes positions on bills when they're working their way through the legislative process. And the governor's administration does that in 2 ways. The first is through the Department of Finance, which is similar to the Office of Management and Budget, OMB, at the federal level. DOF, or Finance, as we most often refer to the Department of Finance, is a group that advises the governor on not only the budget, where they're most well known, but also pieces of legislation that have any sort of state fiscal impact. They are less concerned about any potential fiscal impact to the private sector, but certainly anything that has a fiscal effect on the state government funding, as well as local government funding. And the Department of Finance may take positions, particularly when it comes to legislation that would result in spending state dollars that are not accounted for in the governor's budget proposal. On the policy side, those agencies, those members of the California governor's cabinet, they sometimes take positions through different departments as well as the full agency. So, for example, there is a deputy director with all of the 200 plus state agencies, departments, and different boards and commissions. Everything from the Department of General Services to the Department of Motor Vehicles to the Department of Consumer Services, and all kinds of different ones in between. And if approved by the governor's office staff, those departments and agencies will actually take positions of support or oppose, or support if amended, or oppose unless amended, on legislation as it works its way through the legislative process. As you can probably imagine, if you are a legislator or a sponsor, a group backing a particular piece of legislation, or even one that is just a supporter or opponent, it's very helpful to get those formal positions by the governor's administration, because naturally it signals where they are likely to come down on a particular bill if that bill reaches the governor's desk in its current form. Now, the natural question this leads to is if the Department of Finance or an agency opposes a bill, does that guarantee a veto? Or on the other side of the coin, if they support it, does that guarantee signature? And of course, the answer is no. There's no guarantee, but it's most likely that is the way that they are favoring. And then the governor can also sponsor legislation, as well as even take measures to the ballot. For example, Governor Schwarzenegger placed several measures on the ballot, which were ultimately defeated in his effort to, as he liked to say, blow up the boxes, probably biting off a little bit more than he could chew, and got tremendous feedback from a number of interest groups, and ultimately the electorate defeated some of those proposals. But so too can the governor sponsor legislation. This is another one of those differences in terminology between the federal and state governments. At the federal level, the sponsor is the author. So Senator Feinstein, for example, in one of our 2 U.S. senators, if she authors a bill, she is called the sponsor of the bill. In California, we call the author, the legislator, the author of the bill. We call the sponsor the interest group or individual, for example, who has brought that legislation to the legislator and asked him or her to author the bill on their behalf. And so just a little distinction there. So the governor, just like individual or the California Labor Federation or the California Chamber of Commerce, can also act as a sponsor of legislation. So you can see there's a myriad of different roles that the governor can and play in the legislative process here in California. Next slide. So what I wanted to do before talking about what's on the governor's desk, there are 3 actions. The first 2 are the same as the federal level that you undoubtedly saw and heard about in a civics class. The third is a slight variation from what is available in California versus at the federal level. So just like the president can sign bills sent to him by Congress, so too does the governor in California. This year, as I noted, he has until October the 10th to act on, he's got about 650 bills left. And he's acted on about just fewer than 200 bills so far. If the governor signs it pursuant to the Constitution, which provides for these actions by the governor actually signs a physical copy of the bill and then gives it to the Secretary of State for purposes of chaptering. So while those two things occur on the same day, it's actually that ministerial role of our Secretary of State, Dr. Shirley Weber, of assigning a bill a chapter number that makes it an official law of the state. So not just the signature, but also the chaptering. And those are done in numeric order as each bill is signed by the governor and chaptered. So it's 1 through whatever. A new set of chapter numbers, 1 through, the final number, occurs with each year, even within that 2-year session. And so that's basically what happens when the governor signs a bill into law. And generally, the effective dates are January 1 of the following year. So in this case, of course, it would be January 1, 2022. But we also have bills that, because of what they do, for example, the ones related to the state budget, take effect immediately upon the governor's signature. And so too are so-called urgency clause statutes. Urgency because they're trying to address an immediate problem affecting the people of the state of California. And so they take effect immediately upon the governor's signature and the chaptering that I discussed earlier by the Secretary of State. The second type of action by the governor, if you'll move to the next slide, is, of course, the veto, when the governor says no. And while this is an affirmative act by the governor, like the president, we do not have a pocket veto. We actually have a pocket signature rule, which I'll talk about on the next slide. So again, per the Constitution, if the governor chooses to veto or reject a bill sent to the governor's desk by the 2 houses of the legislature, the Constitution says he has to return it with his objections. That is the so-called veto message. As you can see, it doesn't require anything other than an objection. So the governor could, as simplistically, say that I am returning this bill without my signature, sincerely, governor. That is a rarity. In most instances, the veto messages, while short, generally say to the members of what is the House of Origin, meaning assembly bills go back to the assembly and Senate bills go back to the Senate, with a message that reads, to the members of the California State Assembly or to the members of the California State Senate, I am returning without my signature AB 123 or SB 456. And then generally the next paragraph is this bill proposes to do X with a brief explanation, a sentence or two. And then usually the third and final paragraph, although there could be 2 or 3 or more paragraphs, usually they're very short, is a brief explanation, a couple of sentences why the governor has chosen to veto it. Sometimes those veto messages are very clear that the governor will not consider any similar bill going forward. In other instances, the governor may, in fact, be very explicit for the basis of his veto and say, in fact, that he might invite the legislature to make that desired change and send the bill back to him in the following session where it might be more receptively received. Just like the House and the Senate in the U.S. Congress can override a governor's veto, so can the 2 houses of the legislature, which requires a 2/3 vote. of both houses, not just the House of Origin. And basically, when they reconvene, in this instance, they'll reconvene on January the 3rd of 2022. They'll have 60 calendar days to do it. That joint recess is what they're in right now. They adjourned on September 10th, about 8 o'clock at night, and they reconvene on January the 3rd. If they don't override the veto in those first 60 days of session, then that vetoed bill is no longer able to be considered. As I note there, the last time that the legislature has overridden a governor's veto was 1979 in the second term, but the first go around of Governor Jerry Brown. So even though, for example, the legislature has super majorities, meaning more than 2/3 in both the Assembly and the Senate, they still don't override a governor of their own party. So next slide for the third potential action. Now, as I mentioned, this is a distinction between the federal and state governments. At the federal level, the president has what is called a pocket veto rule. Basically, if the president doesn't act within the specified time period, then a congressional bill is effectively vetoed. California has the exact opposite rule. In other words, if the governor doesn't act on a bill within the specified time, then it is in effect a pocket signature. He doesn't actually sign it, but he allows a bill to become law without his signature. This is rarely done. In Governor Brown's second 8-year stint, I can only recall 2 explicit instances. Maybe there was a third or so. So it's rarely done. Governor Newsom hasn't done it so far in his first 2 years. We'll see in this third year, but again, it's very unlikely that it would occur. But perhaps there's a reason for it. The 2 instances that I recall from Governor Brown, one was a district bill, something that was desired by Santa Barbara County. And the legislator, the assembly member authoring that bill, advocated for it, carried the legislation. The governor didn't think it was something that needed legislation, but he wasn't so it wasn't so objectionable to him that he wanted to veto it, but he didn't think it was necessary, and therefore he didn't sign it. He just let the 30 days expire that he had to act upon it, and it automatically became a law without his signature, and still went to the Secretary of State for chaptering. The other instance was when the U.S. Supreme Court issued its Citizens United decision on campaign finance reform and the ability for corporations to make contributions, et cetera. The legislature wanted to place, which they have to do by legislation, an advisory measure on the statewide ballot, whether or not the people, the electorate, the people of the state of California, were in favor of seeing Congress overturn the People's United decision. The governor did not think it appropriate for the electorate to vote on advisory measures. He only thought that they should vote on constitutional amendments placed on the ballot by the legislature, or constitutional or statutory initiatives placed on the ballot by the people through signature gathering. But he said it's fine if the legislature wants to do it. And so he let it go on the ballot without his signature. Interestingly, the California Supreme Court originally took the measure off the ballot, saying that advisory measures were not permissible. After having the issue fully briefed, they actually ended up reversing themselves, and this was Prop 49 on the ballot, in which the electorate said, yes, they'd like to see it overturned by a congressional act. So Let's turn to what's on the governor's desk with first a brief history lesson. I looked back at the last four governors and just to get a sense of how many bills those governors got each year and how many they vetoed so that you can put in perspective what Governor Newsom's been doing. Governor Wilson served 8 years in office, between 1,000 and about 1,700 bills he got each year, and he vetoed between 8 and 24% of them. You can see the 5 years of Governor Davis's time in office, 950 to 1,450. And he was also at a low level from 6% to 25%. The 7 years that Governor Schwarzenegger served in office, because he took 3 years from Governor Davis's term and then could only be elected to one additional 4-year term. So that's how he served 7 years. A little lower, 900 to 1,250, but a much higher veto percentage. In fact, in looking at all of the governors historically, the Senate Office of Research said that by far Governor Schwarzenegger had the highest veto rate of any governor. And then in Governor Brown's second stint, by the way, in his first stint, he vetoed a low of 1% of the bills, very few, to still single digits in his first 8-year term in the 70s. But he got between 850 and 1,200 bills, a slightly fewer number than Schwarzenegger had seen, and he vetoed 10 to 15% of them. So in our last slide, let's look at Governor Newsom's action. Like I said, he's in his third legislative year. In his first year, he got, I think, 1,015 or so. He vetoed 16.5% of them, slightly more than Governor Brown did in his last year in office, 15%, which did frankly catch a number of Democrat legislators and some interest groups that had backed Governor Newsom in his run for office in 2018. They were a little bit surprised by that number. Last year was clearly an anomaly, as everyone is familiar with. Almost just over 2 months of the 8-month legislative session were lost due to the pandemic. And so they got rid of 3 of the 4 bills. They were shut down in mid-March of last year for the initial first 6 weeks, and then did an additional 3 weeks during the summer months. They had already passed their late February deadline for introducing bills prior to the pandemic hitting. So there was the usual 2,300, 2,400 bills that were introduced by late February of 2020. So they sidelined 3 out of every 4 bills last year in the 2020 session. And as you can see, only 425 bills reached the governor's desk, and he vetoed 13% of them. So far, the governor has acted on about 190 bills. He's signed all of them so far. I would assume that in the remaining 630 or so bills that he'll probably veto the low teens as he has before, is what I would expect. And so we'll see on October 11th how many he's acted on. Thanks for joining me in this little presentation on the governor's role in the legislative process. And I'll turn it back over to Professor Harder. Thank you.
Thank you, Professor Micheli. That was amazing information. I learned a lot, and I really appreciate your expertise. And for those of you who are listening, if you have questions, please do put them into the Q&A, and I will go ahead and share those questions with Professor Micheli in just a moment. For just a couple of minutes, I want to tell you a little bit more about our Master of Science in Law curriculum. So we have 2 concentrations for Master of Science in Law. One is in Government Law and Policy, that is abbreviated GLP, which you see at the top here. And this is what the course load looks like for our Government Law and Policy curriculum. We also separately have a Water and Environmental Law concentration, which I'd be happy to talk about separately. For government law and policy, you have 7 required courses, which are carefully designed to instill in you the theory and then the practical skills you need to be an expert on issues related to using those legal analytical skills, issues related to legislatures, lawmaking, the regulatory state and regulatory compliance, government law and policy, and some skills in leadership and public speaking. You also have the opportunity to take elective courses from which you can choose 3. 2 of them, lobbying and politics, is one taught by Professor Micheli, which he will talk about in just a moment. We also have an election law course, and we have another skills course in negotiation. The 4th option is an opportunity to study directly with a professor to develop a master's thesis. And this can be from 3 to 6 units, often resulting in a published paper or a paper that paves the way toward a new job or a new position. So this is a wonderful opportunity. I work with a lot of master's thesis students and enjoy it very much. Our government law and policy students are also welcome to take any of the electives in water and environmental law, and you see our selection there. So I'm going to briefly turn the floor back over to Professor Micheli to talk a little bit about the 2 courses that he teaches. He co-teaches the first course and teaches the second on his own, so he can give you a sense of what those are about.
Sure, happy to do so. The legislatures and lawmaking courses, you can see, is a study of both the state and federal legislative branches of government. We do spend a little bit of time exploring in much greater depth the roles of the executive branches and even the judicial branches in the lawmaking process, because, of course, the judiciary has the ultimate say over whether or not a law will remain on the books if there's a legal or constitutional challenge. We also spend some time with some practical skills in that course by actually doing some bill drafting and working on bill analyses. And so it's a great opportunity with some real hands-on work. And so we really explore in depth with, of course, a fair amount, the bulk of it on the legislative branch of government, but again, explore in great detail the roles of the executive and judicial branches as well in the lawmaking course. The lobbying and politics is very unique. There are a handful of law schools and a few colleges or universities that attempt to cover the lobbying profession, although frankly, they do it from more of an academic basis. This course is very much a hands-on one. 45 or so of my colleagues in the lobbying corps and I wrote a book on lobbying and advocacy. While it is targeted at the California lobbying, it is certainly applicable, the vast majority, at the federal level and certainly in other states and even at the local level, what we put forth. And we cover everything, as does this course, from becoming a lobbyist to the different types of lobbying, the different types of lobbying clients, even setting up a lobbying firm, to a lot of the practical components, including writing effective advocacy letters, providing effective testimony before legislative and regulatory committees, and then some of the specialized areas of lobbying. For example, we have some very unique boards and commissions. The California Coastal Commission that regulates all development along the entire coast, the Public Utilities Commission that regulates telephone carriers, cell phone carriers, a lot of the app-based drivers, as well as energy companies, PG&E and SMUD and San Diego Gas and Electric, et cetera, are regulated by the PUC and have very specialized rules. For example, do they allow what is called ex parte or individualized lobbying by advocates, or do they prohibit it, et cetera, et cetera. So we really get into the practical aspects of becoming a lobbyist and what you do as a lobbyist, as opposed to a theoretical or academic view of the lobbying profession. We actually delve into the details and actually explain to you what you do and how you do it. So it's a very hands-on course in the lobbying and politics course. So just a brief overview. Yeah.
Thank you, Professor Micheli. And I'll note here that the Professor Micheli's courses are very popular. The first course, Legislatures and Lawmaking, which he co-teaches with an attorney from Legislative Council, is a required course, and students universally feel that they get a lot out of it. The Lobbying and Politics course is an elective course. I think students, even students who aren't necessarily wanting to become lobbyists, find the insights from the course very helpful about how lobbyists fit into the profession. But of course, if you want to be a lobbyist, it's gold standard. So thank you for talking to us about those courses. Last thing I want to do is talk just a little bit about our online framework. Our graduate online courses have an asynchronous format, which means that you don't all have to be in the same place at the same time. It's not a Zoom discussion, but we do structure it so that it is highly interactive with your professors and other students. And I'm happy to answer questions about how that works. But the feedback that we get from the program is that it is highly interactive. They get a lot of feedback from their professors, and they develop relationships with their fellow students and with the faculty. We do have a focus on multiple learning approaches, including quizzes, assignments, discussion, practical real-world assignments, and as I noted, we do develop that community. I am very happy to answer questions about that, either either when we're done here or separately. Feel free to reach out to me. If you're interested in the program, you can start an application online. For those who have attended the webinar, we will waive your application fee. We will be sending all of you who have attended a copy of this recorded webinar and a code. And you will be able to use the code to apply to the program for free. You do not need a GRE or an LSAT test. None of those scores are required. An undergraduate degree of some kind is the typical prerequisite. The priority application deadline is November 1st for our spring semester. Final application deadline, December 7th. But please do reach out to our office. I'll provide the email in just a moment. If you have questions about that December 7th deadline, there's a little flexibility there. And classes do start January 10 for our spring semester. And we also have admissions in the fall. So you can apply for this spring or you can apply for fall. So I'm going to pause here and see if we have any questions, either for Professor Micheli about his presentation or for me about the program. Happy to answer either kind. You see there the email contact information for our program, graduatelaw@pacific.edu. And my email, I'm Professor Jennifer Harder, jharder@pacific.edu. Do feel free to reach out and I will put you in touch with the right folks. So Professor Micheli, I have one question for you, substantive to your presentation. The question is, has the governor's role in California remained the same over the years, or was the governor's role different, and did it change at some point in time?
Well, the formal role certainly hasn't changed since, basically our Constitution was adopted in the 1800s. There have been a number of modifications throughout it, but the fundamental role hasn't changed. Now, as you can probably imagine, different chief executives of the state have been able to use the bully pulpit, if you will, as an example, better than maybe some others. Democrat or Republican. Governor Schwarzenegger came in on a big wave of support, argued that he had a mandate to blow up the boxes, and tried to do that, and ultimately wasn't successful at the ballot box, and he had a mixed relationship with the legislature. It didn't help when he described some of the Democratic leaders as girly men. But so too, the similar thing happened with Governor Davis before him, when Governor Davis told the legislature that it was their job to implement my vision. The legislature had to let him know that they were a co-equal branch of government, and that they had to implement he had to implement their vision as much as they had to implement his vision. So the short answer to the question is that the formal role hasn't changed. As I mentioned, things like the budget coming first from the governor, with the legislature reacting, that's per the Constitution. The state of the state is per the Constitution, et cetera. But different governors have been more or less successful in some of the other things, like the one-on-one lobbying, or the ability to get the electorate to create pressure on the legislature to act favorably or unfavorably towards a public policy issue.
So the individual really matters. That's interesting. Thank you for sharing that. So we have a couple of additional questions. What the first question is, what are the financial aid options for the Masters of Science in Law program? And I'll tackle that. So the financial aid approach, the framework is similar to what you may have experienced in undergrad. You go through that same federal application process, and we have a wonderful financial aid office that will help advise you as to those deadlines. Our graduate programs office is also available to provide advice about that framework and deadlines. We do have scholarship opportunities available through McGeorge School of Law for folks who apply for the program. And my understanding is that you are automatically considered for those scholarships when you apply. If you want to confirm that, reach out to me or to the email graduatelaw@pacific.edu, and they can confirm that. We also, our graduate program assistant, Katanya Kat, who is wonderful, will also work with you to identify subject-specific scholarship opportunities. And if you're interested in natural resources, I also get involved there as well. So lots of opportunities there. Sometimes employers do also offer tuition assistance through employer programs. So I wanted to mention that you might explore that as well. Professor Micheli, did you want to weigh in on that?
If I could, I wanted to mention the tuition assistance as well. I also wanted to say, although I went through the GED program at McGeorge rather than the MSL, still had to get financial aid, and ultimately paid it back. And I view it as I don't want to downplay the cost of any level of higher education, certainly graduate or professional degrees. But it's truly an investment in one's future. All of the Lobby Corps colleagues of mine who have gone through the MSL program have all said that it was of tremendous benefit for their professional growth. And in every instance, they said that it led to them getting better paying and better jobs. So while it is a big investment initially financially, and of course with your personal time, certainly in the capital lawyering program, those who I am familiar with in the capital community in Sacramento around the state capitol have all said they couldn't have reached their job goals without that MSL degree. So it was paid back within a few years, no problem, and certainly going forward.
Thank you, Professor Micheli. I know that I've heard similar feedback from students. So if you want to talk more, any of you attending, about this issue, please do reach out. Happy to provide support. We have just 2 more questions that are related to the program, and then I'll let everybody go. I know you have your days to get on with. So the first question is 6 units per semester considered part-time or full-time status. That is a part-time status. If you need to be enrolled full-time, for example, we have a student enrolled in the MSL program who needs to be enrolled in more units because they are receiving support from the VA. We do have options for students to enroll in more units, particularly if they can come to campus for a course, or if they can do a master's thesis. So again, contact the office if you do need more than part-time status, but 6 units is considered part-time. And that is a traditional track. It would take someone 2 years of 2 semesters each, and two summer courses of 1 unit each at present during 1 summer or 2 summers to complete the program. And we can be very flexible with how that's structured. Some people go all the way through at once, and some people have to take a little time off. The final question we have is, can someone who's already completed a graduate program apply? Absolutely. We do want to make sure that the program is tailored to your needs. So, what we'll do is talk to you a little bit about why you want the second graduate degree, what you're hoping to get out of it, just to make sure it's a good fit and that we're not just, plunking you in there to get more students in the program. We do really focus on ensuring that our students are getting something out of the program. So I have had students who have master's degrees. For example, I can think of one who has an engineering degree who's now in the MSL program. Those are actually very complementary because now she's learning the language of the law in addition to her engineering degree. And we have some who have completed a master's degree in business and now want the law, something like that. So lots of different ways to mix and match, but do feel free to reach out if you have more questions about that. I want to I think I'll pause here. It seems like we're out of questions online, and I know people have to get back to their day. So I want to thank you all for attending. I want to thank again Professor Chris Micheli for taking your time and lending your expertise to us today. I always love listening to you. I always learn something. So thank you very much. And as I said, everybody who attended today will receive a recording of this program and a code, and do feel free to reach out to me as well. All right, everybody, have a wonderful day. Thank you very much.